a nuisance, and what if, under Mr. Monig's presentation to you, what the considerations were financially. It is the responsibility of the board to determine what the period of amortization is based on the criteria in your ordinance, which was put forward to you tonight. There has been 5, counted 6, public hearings. For them to attend every one. No one has been denied their fundamental fairness and the due process. The legislative scheme which you are operating is passed by the state legislature. It's presumed to be valid. Only someone wearing a black robe across the street can declare this scheme unconstitutional. It is yet to be declared unconstitutional. It's been constitutional for 40-some years before tonight, and I would suggest to you that it's probably constitutional tonight. With regard to Mr. Hewing, I would assume the inference is that because my wife believes a certain way, I therefore believe that way too, and that I would vote the way my wife votes. You can search your soul whether or not your spouses you agree on everything about everything, or anything for that matter. I made the comment today, the only thing that my wife and I agree on is that we live together. So I don't think that the mere fact, unless you have a financial interest in this issue, everybody comes to the table, even across the street. Our judges have certain predilections. They have certain likes and dislikes in life, but they put those aside. I would ask you to do the same thing. I know that you will. That's just part of being, in this case, a judge. Look at the evidence. Whatever your determination is will be your determination. But I would submit to you that if there's challenge to the legislative scheme, then that needs to be resolved in the appropriate place, and it's not here this evening. I don't know what your decision is going to be, but if the decision is one which I would assume that Mr. Kluger and Mr. Moning don't like, that they have a process that they can go through to challenge that. And that's fine. That's what our legislature, that's what our Constitution guarantees. So I think that you have gone through the process as you stated in the public that you would do, and have fulfilled that obligation. I'm more than happy, in order to avoid any appearance of impropriety, to allow you to deliberate without me. I think you can make it's what we have now is for you to just use your common sense and judge. You've got the ordinance in front of you. Mr. Moning's seen that. They have presented no evidence as to allocation of relocation costs or demolition costs. At 5 hearings, I didn't hear anybody get up here and offer it. I've been happy to consider it. We've subpoenaed evidence. Haven't got it. Asked for a lease. Didn't get it. They can present whatever evidence they want you to consider. And I would submit to you, you need to consider it. And then make your decision. And Mr. Chairman, I don't know whether how you want to handle issues raised by Mr. Moning, but we're prepared to give you a proposed order. You can throw it in the trash, you can sign it, you can vote. You do have to vote on it. And we'd ask you to deliberate and make whatever decision this board deems appropriate. Yeah, you were appointed by the city council to do just that. And we would ask you to do that. Mere fact that you're appointed by the city council is what the state legislature said is supposed to happen. So I don't see that there's any problem there, unless the inference is that all of you are prejudiced, which is the inference that I got. So I would submit to you that if anyone thinks that they weren't fair, then they need to leave. That's fine. You have that right to recuse yourself. You have that obligation to be fair. But I've never heard one person on this board that I'm aware of at any meeting that I've attended indicated that they'd made up their mind on this issue. Maybe others feel differently, but if so, have them put the evidence on it. Instead of sitting here guessing about it. So with that, Mr. Chairman, I don't have anything further to say. If someone has evidence, if anyone wants to speak, that's up to you. I don't know whether or not you've heard enough or not, but as far as all I tried to do is gather as much evidence as I could and bring it to you. I don't have a desire for there to be any outcome except for what you think is appropriate. That's all. Nothing more, nothing less. So with that, I have nothing else unless you have any questions.
I have two questions. One of the issues Mr. Monning raises is the constitutionality of the statute and ordinance. Is that a proper issue before the Board of Adjustment to address?
I don't believe it is. He does for some reason, but I will tell you what the law, in my view, is that it's presumed to be valid unless there's a court order or a decision of the court that it's not valid.
Was that issue presented to the judges today?
I assume Mr. Dodd was there, not me, but that argument was made, and the judge felt that not necessary to enjoin any of these proceedings. So,
on the second issue, recusal, even though it's made at this date after 4 or 5 meetings, is there some process we should pursue to?
I would assume, and in my view of this, it takes four affirmative votes to make any decision to amateurize this. I think the statute is clear that any decision that's given to you under an ordinance, zoning ordinance, that requires at least 4 of you to concur in that affirmative decision. So from that standpoint, there's no process to recuse yourself. I think that you have to, just from a personal standpoint, say, what they have deposited for us, or for, I guess, for you to consider, is the fact that your relationship with your late wife. So to me, those proceedings didn't start, these proceedings didn't start until she had passed on. So I don't see the issue. I'll leave that up to you personally.
Before you go to the next stage, can I ask you a quick question? You quote the
me or him?
I'm sorry, the New Jersey and Pennsylvania cases you cite.
Yep.
Are there any Texas cases
Nope.
on that point at all?
They're not. But of course, the Pennsylvania court is under the same constitution that Texas under.
Was that issue presented to judges today?
All of these judges were presented. All these issues were presented to the judge today. And in response to your first question, the question as to the constitutionality, that is certainly, regardless of what you do, if an aggrieved party could raise that question later on.
And regarding recusal, I appreciate the way you've postured it, but let me just ask you, are you aware of any basis under Texas law that supports the proposition that an opinion of one spouse is imputed to the other spouse?
No, but I think with all respect to Mr. Hager, I think he demeans, for him to compare disagreements that spouses have, and believe me, I'm an expert in that, for him to compare a disagreement, and I dare say Mr. Holm had many disagreements of the type I have personally experienced with his late wife, just from what I knew about it. That is an entirely different matter than sitting in judgment in a death penalty circumstance on a matter where your wife apparently dedicated so much energy and so much of her resources. That's not, for him to say this is a spousal disagreement trivializes her commitment in my mind. And the answer to your question is, I don't think any opinions are imputed to the wife, but I was thinking of you when I cited the case that says a spouse of a party to a lawsuit cannot serve as a juror, is disqualified from serving as a juror.
The mayor's not a party.
No, she's not a party to a lawsuit. I would respectfully suggest to you that her commitment against my client aligns her as strongly as a party would in a lawsuit. So that's the point I was making.
Other than the fact of my marriage to Mary Nash and my apparently sharing a picture, which I'll take to my house and show that I shared a number of them with her, any other conduct or comment that would reflect a bias, or you or your client think would reflect a bias on my part? Well,
of course, you know that I have only the highest personal regard for you. But at the meeting on, I believe it was November 29th, where the vote was made to bifurcate this process, before you actually made the motion to bifurcate the process, but before you made that motion, you made a statement on the record, and I can find it here. Perhaps it would be important that you see it. You actually said that you were being sarcastic when you made the suggestion that you all might not vote to declare this a nuisance. So I believe that you had it in your mind that this was a nuisance, and you were going to vote that it was a nuisance. And I know that you are a fair, good person in all other aspects of your life, but I don't see how you could be married. I couldn't be married to my wife's every bit as strong-willed as yours was, and that's saying a lot about both of them. But I couldn't live with my wife and sit in judgment of matters on which she so repeatedly expressed her opinion. I'm not that good a person, and with all respect to your goodness, I don't believe you are either. I think it's asking too much.
No other question.
And I'd like to make another point. Mr. Hager hasn't seen this document along. His client saw it earlier. We did sue. It's not at the very top, but if you look at paragraph, you just read the first words, now come Dallas Crown Inc., suing the City of Kaufman and the City's Zoning Board of Adjustment. But I want to make this crystal clear too. This is not a damages suit. We are not seeking to, we have no right to recover damages. You have substantial and important immunities that protect you from any damage claim or anything like that. We are suing you in your capacities as board members because we are fearful that you are set up to do something that is not fair to our client. But I don't want anyone to think that we are making claims that we want to bankrupt or cause economic hardship on anyone, because that's not the purpose. We simply want to get someone to look at this and determine whether in their hearts they should sit on this matter. And as I said, I don't know how you want to proceed with these matters. We are very serious about them. If you feel they can be summarily disposed of and you want us to present evidence, we're happy to do that. Or we're happy to stand aside for whatever deliberations you want to have.
First, let me say that I knew Mary Nash casually. Oh, I'm sorry. My name is Don Fear. I'm the attorney representing the Coalition of Homeowners who were the complainants in this action. I knew Mary Nash casually. I know her husband probably better as an attorney. And if there's anything demeaning going on here, I think it is exceptionally demeaning to come in here at this midnight hour, make a last-ditch effort by attacking the professional ethical conduct of another attorney. There's no doubt in my mind that Mr. Hume felt he was in any way conflicted. He would have said so. And being an attorney, he is aware that we have to conduct ourselves at a much higher standard than the average person does. And I apologize for any attack you've had to suffer. Secondly, time and time again, Mr. Martin, who, by the way, I do not know other than by reputation, and he is a fine attorney, has consistently used language like the work we're doing, our business is over, our concerns about this, if we are closed down. I would just recall the board's attention to the fact that Waldo isn't in business over there. It isn't their business being shut down. But more importantly is at the last hearing, they admitted they had known about this for all these proceedings, and then in 4 hours they hire a lawyer to come running in here to complain of what? They will still own the property, they will still own the structure, they can still lease it to whomever they wish as long as it's used for a lawful purpose. They shouldn't be here. I mean, it's fascinating that they are, but they have no relocation expenses. They have no cost to this whatsoever, except I guess they're losing what is a month-to-month verbal agreement for lease property. If you're a property owner that leases out multifamily dwellings, such an apartment, and somebody sets up a drug lab in there and the cops kick in the door and drag out the drug lab and put them in jail and they don't pay lease anymore, you got some rights to assert after that you can recover? Of course not. You're leasing out the property, either the business is legal or it's not. Waldo has no standing to come in here and ask about these things. As far as www.marynash.org, I have not seen that website, but I can only assume, Mr. Hill, that you don't run that website.
Never visited, never, don't know anything about it.
And I suspected so. As far as what this board is doing, let me tell you that while I found the recitation of foreign states, even though they are on the wrong side of the war of northern aggression, what they've ruled up there, this process has been upheld by courts in the state of Texas about 200 times. And the Supreme Court has repeatedly said it is a lawful process. The legislature has put this scheme together, and the ordinance under which you are acting is almost a mirror copy of most of the other ordinances used in this state which have been upheld. So you're not doing anything which has not already been challenged and already been held to be totally legal. As far as looking into your hearts, well, that is within your purview. But it's not only your right, but your duty to carry out the mandate of the ordinance. You have already voted and found that this is a nuisance non-conforming use. That one we're past. You ordered that some time back. You're in the second part of the bifurcation now that determines when they're to be shut down based on what evidence they have produced. And to mirror Mr. Hager's statements, they've had all this time to come in here and say, well, we need this or that or the other, and this is going to be our expense, and here's what we have to show our moving expense or a relocation or whatever. They've not done that. They've not done anything. They've resisted the process of the subpoena and then come in at the last minute and say, well, we need another 30 days. And I would also point out that the accountant, as Mr. Hager has stated to the board, the accountant was your accountant. He was hired by the city to review this and bring a report, and he did. And now he's visited with Mr. Hager, who is the attorney for this body, and he's reviewed the latest round of documents, the three financial documents that were presented tonight, and has stated it has not changed his view. If it had changed his view, he's been here to tell you that. He has submitted his report, but most enlightening in all of this was, although doesn't operate a business there, and Dallas Crown doesn't own anything there. So if Dallas Crown is entitled to anything at this point, it may be some very minimal amount of time to liquidate its soft assets, which actually did a shutdown, let its employees go and sell its computers. It's not going to sell a building because it doesn't own it. It's not going to sell property because it doesn't own it. So therefore, this idea of recoup its initial capital investment in the property or structure simply does not exist on behalf of Dallas Crown. And I would, as Mr. Monnick said, this issue, or these issues, all of what he's brought you tonight, in their last-ditch effort to run down to the courthouse to try to stop the inevitable, a final vote by this board, was looked at by two judges, a county court of law judge and a district judge, and both of them found all the arguments to be unpersuasive. No, you don't have a right to stop these people. They have a duty and obligation under the law to act as they are acting, and they're acting appropriately. If there was some reason to disqualify one or all of you, it's a little late in the day to bring it up now. Y'all have been sitting here through eons. You've toiled hard and long, and it's been no secret to anybody who was on this board. It's a little late to bring it up now. This body is, as I'm sure your counsel has told you, a quasi-judicial body. The law has been stated very clearly. Your actions are presumed to be legal. You are, in fact, quasi-judges. It's not like you can assume you don't want to do it. You're supposed to do it. And you're supposed to do it under law, and whatever you do is presumed to be lawful, unless they can show otherwise in a court of law. They've got every right to bring a lawsuit later, and I just glanced at the pleadings that were filed. I would agree with Mr. Hager, you all have not yet properly been sued, but that's a matter for another day and another place, like the courthouse, where most of what was said tonight belongs, not here. You certainly can't rule whether or not something's constitutional. And I would submit to you that two judges also had that opportunity today, and both of them said, no, we're not going there. Any complaint about any of this should be brought in a lawsuit later. That's the way the statute's set up by the legislature of the state of Texas. All this board need be concerned with tonight is what date they need to shut down. And I would submit to you that that needs to be a rather expeditious date, since there's absolutely no way they can sit here and claim property or ownership interest in the real property or structure that is being operated as Dallas Crown. And unless you have any questions, I will be happy to sit down and let you all go ahead and deliberate.
Anybody else, Chuck? You like this? Anybody else wants to? Yeah.
I can't see what y'all are doing, excuse me.
May I? Thank you, Mr. Hill. For the record, my name is Mark Calabria. As you well know, from the beginning of these proceedings, I have represented Dallas Crown. And I can say to you quite honestly, since the very beginning of these proceedings, my client has been somewhat suspicious of the reasons that this board was convened, and whether or not we were simply here because we were a business that was offensive to the community. And with all due respect to your deliberations, I would ask you to look around the room and to see who is here. They're not members of your community. They're not here simply because they're interested in seeing this plant closed down for legitimate business reasons or financial concerns for the community. These folks are here simply for one reason, ladies and gentlemen. They have an interest in doing away with horse slaughtering in the United States. I hope that is not part of your deliberations. I hope that you do not have personal concerns or bias or even reasons for wanting to see this business leave the community because of what they do. If you do have concerns about that, I'll suggest to you, I think, as Mr. Monty has subtly tried to do, is that your sitting on this board may not be appropriate. You're very much entitled to have your personal opinions and your own views of what my client does. But I don't think it's appropriate that you use this as some board to launch some personal agenda. It has been no secret for a long time that there are members, both of the elected body of the city as well as members of the community, who do not agree with what type of business my client operates. Nonetheless, ladies and gentlemen, your duty is the same. We are here to follow the law. You're entitled to have good and competent, independent legal advice. Yes, you are a quasi-judicial body, which means that you have the authority to make a decision in this case, but it is to be a free and independent decision, not swayed by the sentiments of the community or even influenced by another party's attorney. Mr. Hager, as Mr. Monty has said, we have great respect for. However, he can advise you and still be the prosecutor in this case. Seems a little bit of conflict. All the members of the community are entitled to be heard. With all due respect to the neighbors of Dallas Crown, I think they have been heard. With respect to the other members of the community that are not members of your community, who come down here and use your power and use your vote to eliminate a business that they oppose, not because of its location in the community, simply because of their personal agenda to end this type of business, I don't believe is a proper forum for you even to listen to their arguments. We would ask you to look in your hearts, but consider the issue that we've raised. We have filed a lawsuit. Depending upon your decision here, that lawsuit can take many twists and turns. If our arguments are right, if some judge across the street over there agrees with us that there is the appearance of impropriety, that you didn't have adequate legal representation, that our issue regarding the constitutionality of the statute, or even the method that you conducted the proceedings is wrong, guess what? We'll be right back here again, maybe with a different board, maybe at a different time. And it's not too late to raise these objections, ladies and gentlemen. We've thought about them long and hard. We've thought about their appropriateness. We've tried to do the research within our means to try to present this to you fairly and openly and honestly. And we'd ask you to very carefully consider among yourselves whether or not you believe there are improprieties, whether or not you believe that the conflicts that we've raised fairly puts you in a position where you are at some disadvantage, or at least putting yourself in a compromising situation. Thank you very much.
I may just address that one issue. I would have to take issue with one of the things counsel said. The cases are very clear on this. The only duty that court across the street or any other court has in reviewing what this board does is to determine that if the evidence submitted to you was so great in opposition to your decision that no reasonable mind could have agreed, then you abused your power. That's the only thing it can do. Whether or not one of you was biased or any of that, there's no case that says the court can entertain any other question except, did you look at the evidence, and upon the evidence, did you make a decision? Even if the court disagrees with your decision, it cannot overturn what this board does. Only if you totally abandon the evidence that was presented to you can the court reverse what you do. And I'm here to say, obviously, there are people here tonight that are horse people. There's people here tonight that kill horses. The same could be said for that side of the aisle that was said for this side. That's not what was presented to you. We like killing horses or we like saving horses. What was presented to you was solid evidence of a nuisance and a health hazard. The hospital certainly doesn't have a dog in this fight. And they said, Lord, we're having to pay for extra filtration. You've got video and stills and testimony, live testimony from homeowners of the city of Kaufman. Their lives have been destroyed by this. So nothing here was given to you, nor do I believe for a moment any single one of you said, wow, well, I think we need a rule in front of for the horse people, or wow, I think we need a rule for the horse slaughter people. No, you looked at the evidence and you determined there was a nuisance. And the evidence was overwhelming that there was a nuisance. The only thing the court can do when they file this lawsuit is look at that evidence and say, did this board ignore the evidence submitted to it? If the answer to that is no, then your ruling stands. It's just that simple. Now, if they want to challenge the constitutionality of the statute, they can do that, and more power to them. It's been tried several times before, and the Texas Supreme Court says we don't have a problem. But they'll have to do it on a constitutional ground, because they're not going to overturn what you do based on any of the other reasons they do. The court simply cannot entertain that kind of argument.
I'm sorry, I can't see the two of you. Y'all are since you're the chair, I just didn't know whether you want us to. I've got other materials I can produce. I don't know what you want to do. You want me to go forward? I'm ready to do that. If you want to deliberate concerning the matters we've raised, I'm happy to stand aside. I don't want them to. Their statements have been made that we haven't produced any evidence. We're not ready to produce any evidence. Not true.
Well, at this point, I don't think we have to change the format of the public hearing, but we can go into executive session without a motion. Is that correct?
No, you have to make a motion to go into the executive session. And
You want to do that before you close the public hearing?
Yes.
Okay.
Do I hear a motion?
I'll make a motion that we get into executive session.
Can I hear a second? I'll second. Motion's been made, we go into executive session, it's been seconded. All in favor say aye.
Aye.
All opposed say
I
no.
read the point of order. I believe it is customary to identify the basis for going into an executive session when you do that. And I don't need to know any statute section, but I'd like to know what the legal authority for doing that is.
we can read the agenda item on here.
Does that mean that since you're getting legal advice from the other side that disqualifies you? The only basis you have is to consult the city attorney, and I would submit to you that since they've raised this issue, Mr. Chairman, I would say that there's no basis for you to go into executive session. So if you want to deliberate, you have to do it publicly, because I don't want to create an issue when there isn't one. So,
That's what I thought. Now, it's fine with me for you all to have executive session and to meet with him. I will stay on the record that I will at no time ever just argue that he should not have met with you, because ladies and gentlemen, in truth and fact, you can't decide this. without getting legal advice, with the level of sobriety that I believe the issue requires. So I will state that Waldo Inc., and I assume Crown Inc., will never, ever raise any challenge to your all's meeting with Mr. Hager, if you wish to tonight, to discuss the matters that we have presented thus far. So I don't want to tie your hands. I believe that he's just, I don't think this business about meeting with executive sessions or not executive sessions cures anything. I think they're either disqualified or they're not, whether they meet in executive session.
I'd also like to raise one other issue, which is the issue that was raised about disqualification, Mr. Hager. I've done a lot of business and litigation and administrative work with cities, and it's been well held that the city attorney represents not only the city, but all boards and committees they're under. He is your attorney. Because you want to play some game, he's going to go over here and do this on this day and do this on this day. Whatever he's doing this day or this day, he is still the attorney for the city of Kaufman. You can't disqualify him from part of, otherwise every board and every committee in this city would have to have a different lawyer. That's an absurd resolution to the issue. Clearly, Mr. Hager has every right in the world to meet with you and you with him. As a matter of fact, if you have a legal question, he is the only person to whom you may turn, unless you wish to go out of session and hire private outside counsel. And I don't think that's a reasonable outcome because you have competent counsel here, very experienced competent counsel. And as far as going into executive session, if you are going to go into executive session, I heard counsel say to consider the matters we have presented here tonight. You have the right to go into executive session. You have the right to go into executive session for any purpose you deem reasonable. It cannot be limited by what one of us say you can go in and consider. So if you can go into executive session, you can consider anything you want in that executive session. It need not be limited to anything that one side or the other has presented. Thank you.
Got the motion and second to go into executive session.
Well, they raised a point of order about what
Yeah.
you're going to disclose to them, what we're going to talk about. Do y'all have any objection? Tell them what issue you want to talk about in executive session.
Basically, this stuff here.
Are you talking about the financial records or the? Well, we shouldn't be talking about the financial records stuff until the public hearing.
I think the only thing you're entitled to do is meet with your legal counsel in order to consult with him about a legal issue.
Yeah.
And ask him a legal question, and then he responds to that legal question. You can't deliberate under the guise of going to executive session to consult with a lawyer.
Yeah.
I mean, I'd be happy to answer.
Is the time frame not to be considered here?
Beg your pardon?
Is the time frame not to be considered?
For the amortization meeting? Not yet. We haven't closed the public hearing.
Right. We can do that. I mean, you can go into executive session, ask a legal question, and then come back because your public hearing's still open. You can still elicit further discussion if you want to from those that have appeared here this evening.
I didn't hear what you said was available. You said you had other evidence. I don't know
Yeah.
what you're talking about.
I don't take one session. I'm talking about the points raised by Mr. Monk. If you want to do that, then absolutely do it and do it with Mr. Hager. But he just wants, I think what Bruce is saying, that Ms. Bonnie wants to just know what issues you're all going to talk about back there.
Yeah, I think you're entitled to know if you're going to consult with a lawyer. And if you all need to talk with Mr. Hager about the issues that we've raised,